There you go, recording.
Okay. All right, so, you know that when we do this each month, most of what we prepare is based on horror stories from the month before. I didn't have to look any further than the last, not even 24, maybe 18 hours. I've had not one, but two problems that both have the same underlying issue that we talk about over and over and over again. And I'm not saying you guys are doing this. Yeah, I'm not saying this, I'm sure it happens very few times here because we slammed it into everybody over and over again. This has to do with knowing you have the correct people signing your listing agreement. Okay, so last night, a client calls me, who I worked with about a month ago, to put him under agreement to buy a new home. This is a widower. Okay, lost his wife last year. So he was going into another house in a neighboring community, and we went under agreement, and he's scheduled to close mid-October. And I said to him, where are you getting the funds for this property? Because he hadn't even put his house on the market yet, okay?
Right.
And he said, oh, I have most of it in cash, and then I'm gonna be borrowing a few $100,000 from my 401k, and I'm gonna have 60 days to pay it back. And I'm planning on putting my house on the market in the next few weeks, and then I will pay it back from that sale. I said, okay. So he calls me yesterday, after Mondays are a busy day because everyone over the weekend's gone under agreement. He calls me yesterday morning and says, we're getting ready to put my house on the market, so can you represent me in that transaction? Of course. So as I'm opening the file to get things started, I pull the deed.
You can only sell.
The deed to the home he's selling. And he,
Which is what you.
that's the first thing you do before you even prepare a listing contract. is
Right,
pull the
who
deed.
owns this house?
Okay, exactly. So when he told me he was a recent widower, his wife passed at the end of last year, I was presuming I pull a deed and find husband, wife, tenants, by the entirety, and that he now owns the house. But the only question in my mind was how much was in her estate when she passed, because there might be others. I pulled the deed, and lo and behold, whoever drafted that deed 15 years ago neglected to put a tenancy on it all. So if you just own as John and Mary, you own as
John and Mary.
tenants in common, right? Which means,
Massachusetts,
go ahead.
the presumption is if it's left unblank, it's tenants in common. The presumption is, so that's very relevant.
Yeah, and-
The reason why, what happens to the property upon death.
So I say to myself, uh-oh, he doesn't realize that he only owns 50% of this house, and the other 50% is trapped in his late wife's estate. So I'm
Right.
praying,
Tenants in common, property passes to your heirs. Okay? Joint tenants, it passes to the survivor. Hugely different. If he had a tenancy on there that said joint tenants or husband, wife, tenants by title, he would own the whole property.
the moment she passed.
So the word is joint tenants in common.
Well,
No,
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 It needs to be.
no.
Joint tenants is good. Husband, wife, tenants by the title is good. Okay,
Nothing automatically tenants in common.
right, and tenants common passes to your heirs.
And the other
It
one
gets really
here,
complicated when you got one bed and one not.
that's the one on this side, that's entire, is that the one that's.
Joint tenants and rights of survivorship, husband, wife, tenants by the title. For all intents and purposes, for your purposes, they mean the same, except husband, wife, tenants entirety is only available for people married. Joint tenants is available by brother and sister, yeah, people are getting married, we get a lot of those. So on, so, yes, we have a question?
No, okay, but I'm believing that this is probably on our licensing exam.
So this is hugely important because her guy doesn't have a tenancy, and in Massachusetts, the presumption is if it's blank, then it's built, it's tenants common. So now he gets, when she died, he keeps the half he owns, her half goes into her estate, she's dead. Okay, so he owns half, the estate of wife owns the other half. Okay, that's a big problem.
Okay, because the estate of the wife needs to be
Probated.
needs to be-
She'll fill
All right,
out
so let's take it,
something.
so Susan, just what you missed is that guy called me last night, current client, is buying a house next month, getting ready for the housing market, I pulled the deed, no tenants. So he didn't realize this. He signed a listing contract himself thinking he's the owner of the house, but he had a joint tenancy. He did not. So I say to him, okay, here's what we have to deal with. Number one, first thing you have to do is get appointed as the personal representative of your wife's estate. Have you done any of that yet? She died last December. He said, no, because I thought we owned everything jointly and I didn't think it was necessary. I said, I understand. I said, but now you do. I said, now, second big question. Did she have a will? I was praying she had a will because it had a power of seal in it, not so bad. He said, no will. I'm like, oh. So it
Now you
just
start
getting
from
better and
square
better.
one with the probate.
We had that happen last year, we did that, remember?
Right.
So then I say,
I'm sorry,
go ahead, hon.
when he said, when you said, did she have a
Oh,
will?
will. He said, no.
Did you then say, do you have a will that's like both of you? Like, is there like?
No, there's no will.
There's no will at all?
Neither one of them had a
The
will.
will is
Wills
only
is
for,
always
only for.
Really? I said I don't have a will.
Okay.
Okay, and we're gonna take care of, and we're gonna take care of that next.
You know,
Okay.
no, don't even waste your time. How many times have you and I had this
All right, well, I
conversation?
will drag him in.
Anytime.
I will drag him in. Okay, so now we have poor guy. He's a widower. He only owns 50% of his house. His wife has no will. So I now have to, the minute, as I'm telling him this, I'm trying to be really calm as I'm explaining it to him. He's having a complete freaking meltdown. All right, meltdown. So I'm like, okay. I said, now on the upside, I said, let me tell you something else, which is gonna sound bad, but this mistake is actually gonna help you. When you die owning property jointly with your spouse, okay, and you inherit the property, one thing that happens the minute any of us die owning property here in Massachusetts is there's an automatic estate tax lien without anything being reported. So the Commonwealth has a lien on your house the minute you die owning property. And the feds have one too, but that threshold is very, very, very high. Very few people, I think I can count on one hand and the fingers left over in my 35-year career, how many federal estate taxes I ever had to deal with.
Is this true even if you're in a trust?
Yes. Yeah. So anyway, it depends on who the beneficiary of the trust is and whether it was revocable and all that. So for this guy's purposes, I say to him, on the upside, the one bright light here is because your wife only had a 50% interest in the house, and you had a 50% interest. We don't have to, for figuring out his potential estate taxes, we only have to tag her with half the value of the house. So I said, how much do you think your house is going to sell for? And he said about $1 million, according to the agent. I said, okay, so last December, let's say, I'm just pulling numbers out of the air. Let's say last December, it was 900. So let's say she had 450 in her estate. I said, did she have anything else, like bank accounts, life insurance? She had a $1.3 million 401k with the inheritance. Here we go.
So
we're
now
screwed now.
he's above the Massachusetts threshold for some reason, and he's above the federal.
No, he's not above federal. No. So she had half an interest in the house, 1.3 in a 401k, $300,000 life insurance policy. And once he had said that, I said, stop talking. I said, it doesn't matter what else she had, you owe estate taxes on your late wife's
So
estate.
this conversation just keeps getting worse.
So he's literally, I think he's gonna start to cry. Because he's so, I feel so bad, I felt so bad, so I was talking really calm, I felt like he was on like a ledge and I had to like keep him from jumping. And I said, okay, so let's break it down piece by piece. The first thing you have to do is, and you don't have to use my firm, we do have departments that handle all these things. And if you want, I'll set you up with one of my attorneys who can handle getting you appointed. I said, but here's the thing. I said, you need to get appointed as a personal representative. And then you need to pursue a license to sell. Because if you haven't got a will, or if you have a will without a power of sale, the only way you can sell the house is via a license to sell.
Okay, just, for those, not everybody says this all the time. The power of sale, what does that mean in a will? It simply says that my personal representative, says my personal representative has the power to sell the property. It's very simple.
It's in most wills.
It's in most wills. But if you don't have that, and it's silent as real estate,
You might as well die without one.
you gotta get the court to grant you a license to sell it. Much more involved. All that stuff.
All right, and before COVID, it was already adding extra time when you had to do this. Now with COVID, the probate court is so backed up
Especially in
that it takes, but the good news here, the one other bright light for this poor guy is the property is in Middlesex North, not Middlesex South. Hallelujah. that's gonna shave some time off. It's not gonna be, so he said, well, can I apply for it right now? And I said, here's the problem. You cannot petition the court for a license to sell until you have a buyer under contract. So you can get appointed as a PR, as a personal representative, but you can't petition the court until you have a contract to show what you're selling it for and what the dates are. And I said to him, and I'm not gonna lie to you, you can't do a 30, 45-day closing. That's not gonna happen. You're talking probably at least a couple of months, if not longer. But I'm gonna try to find out for you, and this is what they're looking into back at the ranch, how long in Middlesex North it will take to get appointed and a license to sell approved. I said, and now you also have to talk to a CPA. Because you have to fill out a form with all your wife, everything that was in your wife's name when she passed, so that he can come up with approximately how much money you're gonna owe the Commonwealth. Now, the good news is that Massachusetts, believe it or not, does not require you to pay the estate tax due before you can sell. If you're under agreement and you can show a closing, like settlement statement, showing that you're collecting the money they say you owe them, they will give you the release because they know that the closing attorney has to give them the money. So that's a good thing.
It's a lien.
Because I had someone last month where it was a very big estate and they owed like $70,000 to the Commonwealth. And we showed it on the settlement statement and we got the release a few days before because the government knew we were sending them money. So I said, so I have now said he's now working with me to represent him in the purchase and the sale. He's working with my partner who heads the estate planning department, get appointed as a PR, and I sent him to a CPA that we use to help him deal with the estate taxes. So now I said, okay, now that we have that kind of talked about, and he's still kind of hyperventilating, I said, now let's talk about the purchase that's happening in 4 weeks. Because now it's not realistic for you to do it the way we had talked about a month ago. I said, get to come up with a plan B. Can you possibly qualify for a normal first mortgage? I said, it maybe you could. I said, you don't have a big mortgage now. You wouldn't be looking for a big mortgage because you have a bunch of cash. I said, but you need a small mortgage, so let's say 300. If I put you in touch with a loan officer at a small bank that I know could do it in a month, I want you to have him run the numbers to see whether you could get just a traditional mortgage to buy that house and not start borrowing against 401ks and 60-day limits and all that stuff. So now I hooked him up with a loan officer too. This poor guy has been on the phone since last night.
The part that's relevant to you is that simple mistake of joint tenants versus tenants common, or blank, as the case may be, caused all of this for this guy. Right? Huge expense, loss of time, not gonna be able to sell his house, immediately, and it'll be expensive.
Andrew, but the most important part is the listing agent has a listing contract that isn't worth the paper it's printed on, because he doesn't own 100% of the house.
It's 50%.
Right, now,
At the moment.
on the upside for her, he hasn't started marketing. I mean, they just signed it. She hasn't spent any money yet. She's just about to send a stager out. He's gonna have, he said to me, oh no, she's about to send a stager out and it's gonna cost me per month. I'm like, no staging yet. Let's get our hands over how long this is gonna take before you start spending money on staging. So,
Key is to run the deed by you guys.
run the deed.
Right.
We're happy to look for it for
You
you.
guys look at.
Either pull it yourself and say, this doesn't look right to me, or say, Mitchell, I need your help to get a deed. No, sometimes.
So that's what happened about 4 o'clock yesterday. So I'm no sooner through that, I told you we had 2 problems. I come in this morning, I have an email from another realtor who refers to a lot of business, and she says to me, I need you to help this lady. She has to sell her mother's house under a power of attorney.
I like shudder when I hear people are selling.
They all find me.
something for
I'm
their-
like a magnet for
They're
these
selling
problems.
for the deceased parent or the alive parent. It's always.
Selling under a power of
danger.
attorney. So I said, okay. So I said, send me the address. I want to pull the deed.
So am I to infer that neither of these realtors did that themselves?
If they did and they didn't question it, then that's scary.
Okay.
So anyway, I pull the deed and the first thing I see is it's in a trust. And I think, oh, this might be better than a power of attorney. It's in a trust. And presumably if this is her daughter, maybe her daughter is a successor trustee. We're in better shape. I look at
His
the,
mom did.
no, she's incapacitated. She's
Okay.
in a memory care facility.
That's what you get in trouble.
So I see it's in a trust. It's in mom's name, trustee of the blah, blah trust. The trust is not recorded, but in Massachusetts, you don't have to record the trust as long as you record a trustee certificate with certain relevant information. I find the trustee certificate back in 2004 when she bought this condo. So I see the trustee certificate identifying her, I see the deed. Here's the problem. The trustee certificate does not identify successor trustee. If
What
it
does
did,
it
I wouldn't have any problem at all. I could just, the lady could sell the house because she's the,
Just identify the trust and didn't.
it said, I so-and-so of the trustee of such and such trust. I have full power and authority to blah, blah, blah. There are no, it's in full force and effect. There are no minors who are beneficiaries. It had most of what you look for.
So is
It
that a
didn't have the
revocable
most
trust?
relevant part.
Now, is that on the
That's
attorney
irrelevant.
that wrote that thing? Because
Yeah.
it should have said, what's the point of?
So I say to the
If we
lady,
don't have a-
I said, okay, so here's, I said, I'm looking at, I said, I'm talking to her now. I said, I'm looking at,
No lawyer that don't rest.
I knew the firm, I didn't know the deal. So I said, okay, I'm looking at this and I see the trustee certificate. Is there anyone other than, are you her only daughter? Yes. Is there anyone other than you that could potentially be a successor trustee? No. I said, that's good too. I said, so here's my big question. Do you know where your mom keeps her important original documents? Yes, I know where the box is. I said, you ever looked in the box and seen something that says, I read her the title? Yeah, I think so. I said, well, I hope so.
This is the trust.
I said, I need you to go home tonight, look in that box, and find me the original trust, because if that original trust identifies you as the successor trustee, which 99.9, I feel pretty confident it will. I said, now what we're gonna have to do is record the trust, which I know they didn't want to, that's why they put a trustee certificate on. That ship has sailed. Now we need to record that trust to establish your title as the successor trustee. I said, but now you told me something else. I said, is mom, because I didn't know this, I said, is mom just frail or is mom mentally incapacitated? No, mom has Alzheimer's. So in other words, she can't be notarized. Because she said, well, my mother can sign her name. I said, no, I don't care if she can sign her name. I care whether somebody can notarize her signature and she has capacity to know what she's doing. Oh, no. I said, then mom's not signing anything. I said, and you can forget the power of attorney that you signed the listing contract with and the offer, because again, not worth the paper they're printed on, because she has no power to use that power of attorney. She has, that power of attorney is good for her to do her mother's banking with and stuff, but not to transfer real estate or sign listing agreements.
What would be the reason why they would have decided not to report the trust?
Most people don't report that anymore.
It's just money.
It's,
or-
no, it's
Divulging.
personal information. There's a lot of information there that you might not want published. But in this case, we don't have
I
a
mean, to
choice.
be honest with you, people that do, a lot of lawyers are doing it as a matter of practice now. I'm not sure it's quite as necessary as a lot of lawyers think, because these
Depends on how
issues,
involved the trust.
these issues come up all the time with, and not being able to, they, like, for example, it also, Emery said about, she said about, didn't identify successor trustee. Well, also it's gonna say, I have the authority granted to me by the beneficiaries. Well, if you leave that sentence out, then you gotta identify the beneficiaries.
Which you don't usually it thinks from trust,
Which-
because you
that's
don't
what you-
want to identify the
Right,
beneficiary.
so now you're gonna do that. So the point being is that trustee certificate isn't done completely. It's as, like you said earlier, it's as if you didn't do it.
So you just do the other thing, and what's that called?
Trustee certificate. Okay. So now she's gonna go home tonight and she's gonna pull that trust. She's gonna bring it to her realtor, who's gonna scan it to me. And I'm gonna read it in the morning. Presuming it has in there what I hope it says, which is that daughter is a successor trustee. Now we have to do another step. In order to establish daughter as a successor trustee, I need to see what the trust says. If the trust says, it has to say when the successor trustee can take their turn and be appointed. Usually it's gonna say something like upon the incapacity or disability of the original trustee as established by a physician. So now I need a physician's letter. I say, do you have a physician's letter? She does. She has a physician's letter. I said, fabulous. I said, so this is what we're gonna do. I said, if we find the original trust, we're gonna record the original trust. Then I'm gonna draft a trustee certificate that identifies you, reverts back to the trust being recorded herewith. And we're going to attach the physician's letter explaining, confirming why you are now the successor trustee, because mom is mentally incapacitated. So these are all the steps. So I have the poor guy from last night. I have this poor lady this morning, well, at least wasn't hyperventilating. For missing, just because both of these documents were missing information that were recorded.
Yes, as it affects you. If somebody tells you I'm selling for my incapacitated parent, all sorts of bells should go off. Because you just can't just do that. So you gotta find out, you have to find out more, or you have to have a lawyer find out more. Because you can't just take the list. Because this person, as Amber said, had no authority to sell this property. And only mom is trustee to it, and mom doesn't have capacity to be trustee. So you're now gonna come up with this, all this, at this second situation, the problem could have been avoided, but you could have got way before you start listening there.
Because the ultimate issue is, let's say you're the listing agent and your client, and you have a falling out with your client, and they don't want to pay you, and it ends up in court. You're not going to win. So you might have spent all kinds of time and money on this house, and you don't have a valid contract, so it doesn't matter.
Yeah, neither of these situations are there valid or complete contracts, either of those.
I mean, with the guy, I might be able to make the case, not with her. She can't sign under a power of attorney. She's signing under the wrong capacity.
What if you have the leasing agreement, and you don't have the seller exactly right because of it being complicated, but then it goes ahead and you get the attorneys involved, and then they are the ones doing all the paperwork and change. As long as all the closing documents.
If your client decides they don't want to pay.
Right. Yeah.
Then you have to litigate,
Right, yeah.
regardless of what happens.
Well, you're just talking about the closing. Like, you're talking about how do you consummate a closing if it started out wrong?
Yeah,
It's not
just like,
enforceable.
if the
Yeah.
trust name wasn't
I
I
right.
mean, here's what the
because-
reality is, that if you go all the way through
You were gonna
everything, and somebody's done what Emery's doing,
Yeah.
yes, you're not gonna have a problem. I mean, the intent is for these people to sell their place, not to try to get out of it.
Right.
But our job as lawyers is to tell you, that you have a contract, this is worth papers.
Well, the listing agent in the trust situation said to me this morning, do you want me to have that offer re-signed and have her sign as successor trustee instead of under POA? Because it's not valid. And I said, let's keep this between you and me right now.
She's not a
Because-
successor trustee.
Yeah.
Yeah, I said, when the buyer's attorney is identified, I will call them and I will be completely transparent, tell them what happened, and offer to edit the offer if they want, because we're gonna do it correctly in the purchase and sale.
So I might have missed this, covering a lot of stuff, but just long story short, if a son has a power of attorney for his mother, right? And in the power of attorney, it gives him the right to sell her assets and things like that. If the power of attorney has been, it's enacted.
As long as she's,
That's
that
okay.
legal?
If
as
it's,
long as
if
the
it's
person's
validly executed, it's fine.
yeah, the person's confident.
Now,
No,
no. she's
No, it
not
depends on how the
confident if I have
power-
of
it
attorney.
depends on what the power of attorney says. I will tell you this, title insurance companies, as a rule, hate taking deeds under power of attorney, but they can't refuse them if in fact they're properly drafted
Right,
and
but I,
executed.
but I would tell you that a lot of lawyers, buyers, attorneys, put a clause into their rider saying that the owner or the deed has to sign. And it can't be signed.
So we just have to strike that out.
So,
Right, but I mean, the truth of the matter is, if you should already know the answers to all these questions.
But I get 50-50 from all different, oh, you can't sell property in the POA. I'm like,
No, no.
it says right here in the POA, I can sell
No,
property.
no, but it's not that's not a legal question.
Mhm.
It is a contractual question based on what I just said, or it's a title insurance company underwriting. It's like Amy said, title insurance companies are not happy with deeds.
I hear what you're saying.
Let's say, let me give you, I think this is gonna crystallize it for you. Let's say we're selling our house
Yes,
and I'm gonna be out of town.
Right.
He's going to the closing.
Mhm.
The closing attorney doesn't want a deed signed by him for himself and under power of attorney for me, his wife, because I have capacity and I'm alive and I'm fine. They want me to, before I leave town, they want me to have my signature notarized on the deed and just give them a power of attorney to sign the closing documents. If I'm in a memory care facility and we have a valid POA, that's a different story. It's the whole reason we do it. They have to take that.
but operate on the premise that you need a wet signature by the people on the deed. Yeah, there are ways of getting around it under certain circumstances, but just make it simple. If John and Mary are on the deed, John and Mary are around, just because it's inconvenient for them, which is when these things generally come up. Like, they're moving from Texas and one of them's here and one of them's there. Oh, excuse me, two Texas, and one of them's here, one of them's there. Well, sorry, it's inconvenient, but that's kind of what we need to do.
So, I know you're gonna move forward, but maybe it's following up, or maybe it's on the sheet you're gonna give us today.
Well, no, we're not
Top
getting any
five
sheets,
questions
these
we
are
should
all
be
talking
asking.
points.
What are the top 5 questions we should be asking our clients if we are presented with a seller who says they're POA or trustee?
The first thing you do, if you're taking a new listing, the number one first thing you do is say, I need a copy of your deed. You can pull it yourself online.
Right.
And if it doesn't say anything other than exactly what you're expecting to see, if it looks the least bit freaky or funky, then you ask them about it. And if they can't answer because they don't know, you call one of us and we'll figure it out.
And
Just don't have them sign anything until you feel 100% certain of the right people.
Marketing point of view, you look much better to this, when you look prepared when you show up and you have, I pulled your deed and.
Yep.
As opposed to, because these two situations that Emery's talking about, those two realtors, hook, line, and sinker took the story from the lay people that they were talking to, and they were both wrong.
Although on the upside, the lady with the trust this morning, when I walked her through this and explained what the problem was and what we were gonna do to fix it, after a 15-minute conversation, at the end, she says to me, I really like you. She's like, you explained it really well, and I feel very confident you're gonna figure it out. I said, I don't know, we're gonna figure it out.
I'm gonna put it specifically that.
Yeah.
And people don't want to hear they have to spend more money on the sellers. They don't want to hear. They don't want to hear. So this stuff now gonna cost these two folks.
Believe it or not, that neither one of them said that. They're much more worried about how the heck
Well,
they're
because
gonna do it.
they can't do what they want to do. The point is, they will.
Yeah.
Once they get over the shock, they'll start complaining about the cost. That's the way it works.
All right, so I think we've beaten that one to there, but if anybody has a question about it, if it's something you want us to find point, you can call either one of us and we can talk, about it again later. Happy to do that on any topic.
So your first case, joint tenancy, you absolutely see.
You need a tenancy of
Tenancy.
some sort, okay? The difference between people who are unmarried, okay, an unmarried couple has a choice of a tenancy in common with a state percent interest. You don't state it's 50-50. You don't have to do that. You can be a boyfriend and girlfriend, one's putting more money in than the other. So let's say she's gonna have 60%, he's gonna have 40. You can say that. You can say that, that's tenancy common. If you wanna hold, let's say they're engaged, they're getting married in a couple of months. They want a joint
Those are
tenant.
Dicey ones.
Yeah, so and you know what I say to them very delicately when I'm sitting with them, because, they might not both think the same way. And I say to them, there's no right or wrong answer here. And it's changeable. So you might take as tenants in common today and call us a month from now when you come home from the honeymoon, and we'll turn you into a tenancy by the time.
The Dicey one is not fiance, so it's boyfriend, girlfriend. Because they don't even necessarily have, because then you have to, so you get married, that's kind of questions we have to ask, because you can't come right out and say, what are your intentions?
No, but you know what, but what we do, you know what
My
we
daughter.
say, what we say to focus them is, I say, this is very morbid, but I have to ask this
What do you
question.
want to happen?
If God forbid something happened to either one of you, would you want the other to take the whole property, or would you want it to go to your parents or your siblings or
That's such a
someone?
good timely thing for me to hear, because my daughter's under contract right now. She, her boyfriend, the baby, they're not married.
Right.
I assume they're gonna get- So
That's,
I'll have to have that conversation
Yeah.
with her.
They, you know what, they need
Coming up.
even more, they need a state,
Yeah.
they need a state plan. Because they need to have something that says, God forbid something happened to one or both of them, who's gonna take the baby?
Of course, they have a baby, that's.
The minute you have a baby,
We all
you need a
know
state
that
plan.
not everyone does that.
You have a 17-year-old baby,
He doesn't have a little-
shame on you.
With
Okay.
a cocktail napkin somewhere that spells it out.
Oh my God. Okay, all right, so let's do a couple of quick things here. I'm seeing over and over again something which you would think is common sense, but apparently it's not. On a daily basis, yesterday, at least 3 times, a realtor sent me a copy of a deposit check unredacted. It's like asking for wire fraud. Do never send a copy of a check. I've had people send me wiring instructions or like a seller, we tell them not to do it and they don't, it says it in the engagement letter. Don't ever send us any, your social security number or wiring instructions online. Don't do it. It says it in the letter. They really don't read the letter.
Right.
But if you are sending a signed purchase and sale, you on the back of the PS, you have a copy of the check. Before you send it, make a photocopy of that page and just black out the bottom of it.
Right.
So that we don't see the account number. That's all you have to do. It's really easy. But you'd be amazed how many people, and all that's gonna happen is somebody to lose money in a fraud, some kind of fraud, you get sued. You're absolutely getting sued. So when people send those to me, I print it and then I double delete it out of my computer. I know there's other clouds where people can get it, but at least I get it out of mine. No,
All our clients have to sign an advisory form now.
good.
That we've advised them not to do, but we just.
Yeah, but this isn't the client's doing it, this is the realtor's doing it. Realtors are doing
realtors
this to
send
me
it.
every freaking
But the
day.
client still said, I'm like, send me a copy of a deposit check or blank out the things.
I mean, it's the same thing,
Nope.
Rod, as an aside, when we're doing these repair agreements on this, between the parties, independent of the person's survey, and they submit it to the bank.
They attach them.
The whole
We send them
purpose-
separate, and
Okay,
people
we're
send it back as one PDF, and I'm like, why did we do it? Why
The
didn't we
whole
just?
purpose of
put it
doing
in
it
the
separately was to avoid that.
Happens all the time, all the time. I found out something I did not know. I still learned something new, even after all these years. The other day, I had a situation where a woman calls me, we had just gone under PNS. She and her husband were buying their first house. And she's panicked. What's the matter? They might not be able to approve my mortgage, because I just found out this particular bank. She said, apparently, she said there's a Fannie Mae, which I didn't even know about. If you, right now, during COVID, student loans are being, paused. So they're in for, a lot of them are in forbearance, not all of them, but a lot of them. This lady's, however it worked out, between she and her husband, they have like over $100,000 of student debt. And right now, they're not paying anything on it because they're in forbearance. When you have student debt, this is something I just found out about. If you have student debt, most lenders tag 1% of the student debt as against your ratios. So in other words, when they look at your expenses to see if you can afford the mortgage, because you're not paying anything, like before they were paying like between the two of them like $700 a month. But now they have like $130,000. So now it's $1,300 extra a month that arbitrarily the bank, but, no, it's worse, This bank does 2%. So it's gonna be $2,600 a month in their ratios on top of their car loans and their credit card debt and everything else. Blew the ratio out of the
It's
water.
gonna wipe out.
So I said, I never even heard of this before. Let me call up another bank and see if this is a Fannie Mae thing or if there's any way around. So I called the little bank, bank that I work with for a long. I said, you know what? He said, oh yeah. He said, everybody has to do that now. He said, it's 1%. I said, well, this other bank is saying it's 2%. He goes, that's them then. That's not the Fannie Mae. It's only 1%. So I called her back. I said, if they can't get around this, you need to swap over to a different bank that only tags you with 1% to see if they run the numbers and you qualify.
How new is this?
I don't know when it
Mhm.
happened, but it's happened since COVID. So that's what I'm saying, is if you are working with young people that have gotten pre-approved, don't be afraid to ask them if they factored their student debt. If it's in forbearance, that's a question they have to ask the loan officer, so that the correct amount is being factored in.
What if, okay, so, I don't know too much about this, so when somebody, just because people didn't have to pay their student loans, if they did continue on just paying.
If they were
regular,
paying,
that's
if they didn't have to take the forbearance, if they were just paying
Yeah.
the $700 a month, they would have been okay. But this was some situation where the way she explained to me, it had to do with her work, and they automatically put her into forbearance. So she couldn't even, she couldn't like reverse. I said, well, can't you just go back to paying? And she's like, no, apparently I can't. It's not that easy. But I don't know what, they figured it out somehow. So I don't know what they did, because the loan officer said to me, we got around it, we're okay. And I'm like,
The point being is.
point is, this is something I never even knew about. I just found out about last week.
And then for the ones that do the forbearance, when they start paying again, do they just pick up where they left off, or do they have to like make it up in some way, or just?
I think they still owe everything. It's just like, it's kind of like, you know how right now they can't
Just
evict
more
people?
advanced, right?
It's the same thing like evictions. Right now, you
You
can't,
still owe the
you
rent.
still owe the rent. And if you don't pay, you end up in housing court, they could make you pay everything you have to pay. Good luck getting it, but they, it doesn't mean it goes away. And I think, I'm not 100% certain, I think it's the same thing with the student loans.
Well, with the student loan, you just extend the term, but with the.
You can refinance
the
it, too, I
rent,
suppose. Yeah.
and what, I mean, then you really would have to pay more per month.
That's-
But you,
So it's not gonna be landlord.
The problem with this is that it came out of nowhere. These kids had no idea about this. And it just, they've already signed the purchase and sale, they're already mentally married to the house.
Right.
We have a financing contingency coming up in 2 weeks, and they're thinking they're gonna get a denial letter.
Okay, so here to your loan officer, who was probably referred this deal, should have been asking that question the first time, and not waiting until.
I think this particular loss, I don't think it happened to her. Like, I don't think that I think that it came out of like left field for her as well. Maybe she just do a lot of business and she's the first time she had somebody with student loans that were in forbearance. It was just like a freak thing. You wanted to talk about the differences?
It's important that you guys, as you approach transactions that are doing business in Massachusetts, both know the difference. There's differences between the states. Some of it's more relevant to you than others. Most obvious, the most significant one is the purchase of Massachusetts. We have an offer. The offer gets into the hands of lawyers, purchase agreement is drafted, and offer folds into the purchase of it.
Right.
In New Hampshire, there's only one document. You guys, unfortunately for you, draft it. And you're gonna have to act as pseudo lawyers. But there are other differences. One that we talk about fairly frequently is in Massachusetts, we have septic system, septic system Title V requirements. New Hampshire doesn't have that. In New Hampshire, Massachusetts, we have smoke detector, carbon monoxide detector law. Insurance of the student, they don't have that. Massachusetts, we have a document about lead paint. It says if it's good, if it's the house is built prior to 1978, it's not supposed to be lead painted. They don't have that. But it's not
There's
state.
no-
that
it's not a
is-
state
It's
law.
not a state law.
Federal law.
Yeah. Louis formaldehyde foam installation. Have that document in Massachusetts. Don't have the document. I only tell you this because I've had some transactions in New Hampshire recently. This is a different topic, sort of, where there are title issues. So the poor listing agent gets put in a position, because that's all there is, of having to deal with solving the title problem. And what? I know you said no, but there's.
It's not the most important thing they don't have in New Hampshire.
Oh, Mitchell?
You know the most important thing they don't have in New Hampshire? Underline this 15 times. There's no certification of title.
Oh, yeah, right.
So if you buy a house in New Hampshire with title insurance, you need your head examined.
Right.
Because there is
There's
no one to go
certification
back
title.
to. No one owes you anything in New Hampshire.
Right, so when I say Wild Wild West,
At least here, I mean, you still should buy it in Massachusetts, but at least here, you have an attorney who you can call who certified the title if you were getting a mortgage. If it was a cash transaction, again, there's no certification, you should get title insurance. But there's someone to turn to. There's no one to turn to in New Hampshire.
Let me ask you this. So that's customarily perhaps how properties transfer to New Hampshire. That doesn't mean as a good buyer agent, I can't recommend to my client that they hire an attorney and get a title search done on this property. And why isn't their bank, well, their bank.
The bank
is
does
title,
the title search is done by
but there's no title insurance? I'm
No,
confused.
you can buy, you should buy it.
the local in Massachusetts.
Yeah.
She signed a document called the term certification of title.
When
It
there's a
doesn't
bank involved.
exist.
All right, so there's still a search done, but there's no one certified.
That's right.
Okay.
So the title company that Summit Title or Accurate Title, one of the various ones, they're doing that part of the job,
But they don't certify.
but they're not certified on it. And if your buyer thinks it's more important to buy a sofa than buy owner's title insurance, has nothing, has nothing.
remind me now, PNS in New Hampshire, does it say that it must be an insurable title?
I believe it does.
So the buyer could make a claim that they want their title company to certify it, or we're gonna get an attorney.
No, the role that the title company is performing in terms of insurable versus market, it's the same thing. They're doing the same thing. You're having a lawyer represent you as a buyer. My conversation is more about the seller side.
Okay.
The buyer side, you're going to get pretty much the same services. But if you don't buy title insurance and you're not getting a certification and you have a problem 5 years later, then you're going to figure out it's tough to go after. I'm talking about when there's a title issue comes out of the buyer side title examination. Listing agent becomes a de facto lawyer because the customer still knows nothing, just like they know nothing in Massachusetts. There's no lawyer to step into insurance. Make sense?
Another reason that even though we certify title in Massachusetts, okay, the reason you still buy title insurance is that our certification doesn't cover 100% of what can go wrong. It only covers certain things. We're not held to what I like to call a standard of clairvoyance. So if there is something misindexed at the registry of deeds or someone committed fraud, that our certification doesn't cover that. Okay, so that's why you want to have that. It's kind of like a safety net. Also, what if you have a sole practitioner
That's the issue.
who
So many,
retires or
so
dies?
many people are
The
using sole
certification is
practitioners.
useless.
If they retire, if they die, they sell cars, you got nothing. You got nothing. And if they just continue, they don't have, or they don't have malpractice insurance, which sometimes single practitioners don't have, because you're not required to have it. Lenders might require it, but
If someone calls us that closed with us 20 years ago, we're still going to help them because we certified titles to them 20 years ago. And if we will use all efforts to fix it, if it's something we can't fix, depending on the problem, then we would work with their title insurance company.
hopefully.
Hopefully,
Yeah,
hopefully a title, it's very rare that anybody working with us doesn't buy title insurance. We'd be impressed upon them how important it is. It's very rare. But now the first thing we do is we try to help them. Because not all buyers just want the insurable title. They might say, until you fix the problem, I don't want to close. So we try to help them fix the problem, not just insure over until it can be fixed. You don't have that in New Hampshire. There's nobody is going to help you. I got a referral this morning from a realtor in New Hampshire, sending me some buyers and along with the signed purchase and sale agreement, and invited them to call me for representation. So when they called me, I said, let me be really clear here. You don't need my representation. And I explained the differences. I said, you've already signed a contract. What you need is a bank attorney. I said, and he's referring you to me because he has experience with me. He'd like me to handle your title and closing aspects. And so there's no extra fees to you. We don't take money up front. The lender you picked is going to tell us what we can charge. We don't even get to set the fee. And whatever he told you, we have to work with. And we're going to search the title and conduct the closing for you. But there's no representation of you necessary at this point because you've already signed a contract. He's like, oh, okay, that's good. I said, now if you have a problem, obviously, we'll find a way to get you help, but you're not calling me to represent you.
but that's again how it affects you. Not everybody's us. You're just not going to like that.
brings up a question that you said about, okay, so are you saying that, when you're doing the closing, right, for the bank,
We're in New Hampshire now.
we're in Massachusetts, actually.
Where there's usually dual representation where we represent the buyer and the bank.
Right.
99% of the time.
I guess my question was, if you're doing the bank work, is the bank, no matter who the bank has to it, are they all gonna pay? They're gonna pay the same to any attorney that's doing that closing, right? Or not?
Most lenders have fee schedules, so they issue a loan estimate and they'll write, let's say the average one is like, I don't know, $800. Okay, so they'll write down $800. And because I asked for them to send me a copy of their loan estimate, so I make sure I know what I'm allowed to charge. And out of that $800, we have to pay the title examiner and we have to handle all the document preparation, the certification of title, the disbursement of funds, and the conducting of the closing. We don't get to say that's not enough, we want more. If we sign on to do it, we have to live with whatever fee they
So
quote.
you can charge what they're gonna or something less than that. It's like a.
Oh, I was sure.
I'm not
I don't
saying you
think-
would or
Don't
should.
be,
I'm
don't be
just
holding
wondering-
your breath for that one, I guess.
No, we usually live with whatever they quote, you know, I mean, most places
It's
quote
just
an average.
interesting
anyway.
when we're trying to, get people to work with the people we want. It's nice to know how it works, so that. if
Well, the only,
vendor's telling
the
us
only
something-
differentiation in Massachusetts is if there's gonna be a dual representation with the attorneys representing both the buyers as well as the bank. Most lawyers charge for the personal representation. But, and that's negotiable, or that's whatever decide, that's, the bank has to do with that. There are some that still do it as a throwaway, they don't charge at all. But you typically get what you pay for.
And there are some people that still, even though they're the bank attorney, they somehow get away with charging like by the hour. So I see like, I look at settlement case and I think, wow, we're really cheating ourselves. Because I see people charging like crazy money for the personal rep, plus they get paid for the bank rep. Like we charge a flat fee, like a throwaway fee.
Well, and truth be told, if there isn't folks like you involved, in consumer, that's not good. I said that someone costs you $5,000 to sell a house, okay. No.
So when we refer to look at looking information, if a buyer is referred to, or a buyer has an attorney, does the attorney represent the bank, or is it always dual representation?
No, it's not necessary. You have to choose that.
So you would advise your buyer or your seller.
Well, your seller, there's no banks.
Okay,
So
so
there's
you-
always a.
So they're representing you at a flat fee.
Right.
In the case of a buyer, the bank has to represent,
Has to be
has to be represented. You can have full representation, and you can charge
We can charge whatever we want
for the extra.
for the
For the
personal part of it, which is primarily P&S, enforcement of P&S.
But you guys typically just take it as whatever the banks,
For the bank
Only
side.
for the bank.
only for the bank.
But here's the important part of what you just said. You have the unsophisticated buyer who maybe, I mean, it happens a lot. They meet with the loan officer first, hopefully, and get
Right.
pre-approved. And the loan officer says, oh, I'm gonna have you go to my friend so-and-so attorney who's gonna handle the closing. In their head, the buyer thinks that means that's his attorney. It's the bank attorney, unless you hire him or her to also represent you. And a lot of times, people don't get that distinction.
And
They
if
just
they're not getting it-
presume
if
they're getting
not
personal
hearing it from you,
representation.
They aren't gonna get this.
Okay.
Because the loan officer,
Extra for it, they like not getting anything special.
the loan officer always is gonna say, use my friend Joe. Always.
Which we like, because there's plenty of loan officers that send them our way.
Right, but it's not what they know. So that's the thing. And
So what do you always tell them, the question to ask is not, are you using attorneys? Who's your attorney?
no, this one taught me that one.
Right.
I learned this from you 20 years ago.
Right.
She said
So
to
when
me that you don't say to your client, who
Are
are you using a lawyer, buyer side, or seller, doesn't have to say. It's who is your attorney?
So if you're working with a buyer and you say, who's your attorney? And they say, oh, the ABC Bank told me I'm using John Smith. You say, no, not the bank attorney. Who's your personal attorney? Did you ever talk to Mr. Smith to see if he would represent you too? You have to link that together so they know they need to have the conversation.
Just like who's your real bank?
Right.
I use it for the.
Because if you say to somebody, are you? and it costs you money to say yes, then the answer will be no. Or if you want to sound smart, and you know what you're talking about, you say, oh, no.
You guys do that, like,
Mhm.
when you do this, what do you guys actually do?
It depends. I mean, like right now, you can't go, we used to go to all the different registries, but the registries are closed. We can't do closings now.
Yeah, some of them are open.
So we have to like play it by some. Sometimes we'll offer to go to the realtor's office in the county where it is, but then we tell people if we do that, we're happy to do it, but then we have to drive it back to get it e-recorded. When we tell them that, there's gonna be hours lost, they usually say, we'll just come to you so you can e-record it the minute I
But
leave.
the general answer to your question, when normal circumstances that are not COVID, the answer is yes.
Yeah. Yeah.
All right, anything else, guys, that you can think of?
That's great.
What I'm gonna try to do is, I'm gonna try to see if I can link up next month's with the,
Well, I'll ask you, do you guys prefer having a separate thing that you have to make a special trip here, like it is today? Or do you prefer to have us meeting after the shareholders meeting? This month, for some weird reason.
That's something we're doing.
I like the separate trip. We have, some of us have short attention spans. We don't have
It's a long
4
time to
hours
sit there.
Yeah, I don't like, tired of listening to all the
It's
other.
just me. It's just me.
Yeah, I've got a.
Let's try to get some more people to
We've
show
got
up.
to, that's.
And RSVP, so we get the right amount of food.
And usually,
So, all right.
What we need to do is get the people who need to be here.
yeah.
That's always the plan.
There's always excellent information.
Right.
Every time I walk.
Yeah, really is.
I don't think we're gonna tell you anything that, everything you want out of here with, you came in with. I don't think that's ever gonna.
And you're always gonna come up, there's always gonna be something on a monthly basis, if not a weekly basis. Some wrinkle that never happened to you before. It still happens to us, and we've been doing this for a long time. So don't be embarrassed to call us and say, hey, this just happened, what should I do? We'd rather tell you, because the whole reason, we do these for 2 reasons. One is so that you can have smoother transactions, but the bigger reason is to keep you out of trouble. So if you think there's something you don't understand, make the phone call, stay out of trouble.
The worst thing you guys can do is be afraid that you're gonna embarrass yourself in front of your client by saying, I don't know, let me check into it. Instead, we'll just guess. 50% chance of being wrong. And I'm telling you.
All you have to do is replace, I don't know if, let me double check.
Right,
Get
absolutely.
back to you.
Right.
Double check on that, get right back.
Well, I just want to say that I really appreciate how accessible you guys are during a transaction, because I just had, you guys already heard me yesterday, but I just had a string of situations where there's already another attorney in place. And they're not doing anything. Purchase and sales are supposed to be signed. Not only does it not get drafted and reviewed on time, if it's not going to be, nobody reaches out and says, hey, this is gonna be, we're gonna extend.
Let me tell you something.
Nothing.
Unless
Signed.
you do this,
Yeah.
unless you do this on a volume basis. Emery has a different place. She's in Lexington area. Her average is $1 million per transaction. She can afford to. She doesn't do less than she can afford to. do less. For me, up in the Merrimack Valley, southern New Hampshire, the margins are pretty small. So that being said, is if you don't do this on a volume basis, it isn't worth doing unless you're going to cut corners. Right? You only give people one link, that's what it is. So that's what you get.
Yeah, I mean, when you have a purchase and sale or a deal going on that something's supposed to happen on Friday, and on Friday, we had finally the very first final conversation with the attorney who says, come on, Robin, I want to get out on my boat. And I want to say, if you wanted to get out on your boat at noon on Friday, how about dealing with it on Thursday or anytime during the week? No, I'm not, sorry, guys.
Can I tell you something?
This is what they turn into a therapy session.
Don't underestimate the fact that we have a live person answer the phone.
Yeah, that's a bonus for sure.
Because most of the places I call, you go right to voicemail and you're just leaving it out there in the ether. But at least somebody answers and connects you with one of us.
Maybe. Nobody will. I just.
Thank you.
You're welcome.
Another interesting thought is so
All right, that's fair. Yeah.
All right, I'm gonna get your recording up there. Obviously, my phone. Yeah. I got the file. All right, guys, see you next time.
Thank you.
Thanks.
Okay, thanks.
Thank you very much.
Thank you.
You're welcome.
Yeah, thank you, guys.
So I started on lately, every time in Massachusetts, sign by a certain day and time. It's like 9 o'clock at night and it's, it's like, so I start being proactive. Actually, it was the holiday weekend.
Well, those are always bad.
So I said,
I looked at it before I got.
Tuesday, I'm like, hey, everybody, we got this holiday weekend coming up, everyone on board? think I signed mine across Friday
How did the lawyer get that?
night. On that
Was
one,
it through the customer or through the lender?
The ones I have issues with are all my customers.
lender on that,
That's a bigger problem.
yeah.
Because they're not, see, they're not afraid. They don't care about you as a because you're not referring to business.
Right.
They care about keeping the loan officer happy. And the loan officer that's got to.
My buddy Joe,
I
who's got,
I wanted to wait, because I didn't want to wait triple.
and then I have great real estate agents who come and be proactive about PNS before
Right.
someone goes on vacation or gets on the
Yeah.
road, right?
And how they do that, I have no idea, because they're doing everything themselves.